Please be seated. The sitting is open. The court meets this afternoon to hear the single round of oral argument of the United Arab Emirates on the request for the indication of provisional measures submitted by the Republic of the Sudan in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan. I now give the floor to the co-agent of the United Arab Emirates, Her Excellency Ms. Lim Cadet. You have the floor, Madam.
Mr. President, members of the Court, it is an honor to appear before you to represent the United Arab Emirates. I begin by expressing the UAE's solidarity with the Sudanese people and our deep concern over the 2 years of devastation and displacement that has been inflicted upon them. The destruction in Sudan is truly heartbreaking. The unrelenting violence, attacks on civilians, and horrific acts of sexual and gender-based violence must stop, and their perpetrators must be held responsible. But that is not what today's proceeding is about. It is not about our obligations under the Genocide Convention. The applicant has not brought this case before the court to ease the suffering of the Masalit people. The real motive and sole objective of the applicant, who is one of the warring parties, is to misuse the court to make their false accusations against my country and to deflect from their own responsibility for this war and their violations of international law. Mr. President, we should not be here today. There is clearly no basis for the court's jurisdiction in this case. The UAE's reservation to Article 9 of the Genocide Convention is a legitimate exercise of state sovereignty. This case is an attempt to circumvent state consent, which is a bedrock of our international legal order, its very foundation, not a mere formality. It would be a significant threat to the integrity of that order if jurisdiction is exercised and provisional measures are granted in a case where there clearly is no such state consent. The UAE participates today out of respect for the court and the principles of international law and justice, even as we firmly maintain our position on jurisdiction. I affirm my country's deep commitment to the international rule of law. That includes the UAE's unwavering commitment to its obligations under the Genocide Convention. Mr. President, since its foundation in 1971, the United Arab Emirates has been a partner and a friend of the Sudanese people and the Republic of Sudan. The UAE's historic relationship with Sudan has been rooted in a commitment to support Sudan's prosperity and stability. Prior to the outbreak of armed conflict in April 2023, the UAE invested more than $4 billion to support the Sudanese people, strengthen Sudan's institutions, and progress its transition to a civilian-led government. Of particular relevance to the claims you heard today is our support for Sudan's stability under the framework of a military cooperation agreement signed in July 2020. Notably, official requests for assistance from the UAE came from General al-Burhan himself, in his capacity as President of the Transitional Sovereignty Council of the Republic of Sudan. But this stopped in April 2023, when General al-Burhan and his then deputy, Mohamed Hamdan Dagalo, turned their factional power struggle into open warfare, plunging the country into a brutal and entirely avoidable conflict. Since the start of the war, the UAE has not provided any arms or related materiel to either of the warring parties. Rather, since the very beginning of this conflict, the UAE has worked tirelessly to alleviate suffering. The UAE has engaged with partners, including the United Nations, to deliver over $600 million of assistance to support all of those in need throughout Sudan and neighboring states, without discrimination. It has established field hospitals in Chad and South Sudan to assist those fleeing the fighting, including Masalit refugees. Our medical teams are treating all of those in need, regardless of ethnicity, societies has expressed appreciation for the critical role the UAE plays in advancing global humanitarian efforts. The UAE has been clear and consistent in its position on Sudan. There is no military solution to this conflict. The UAE has called for an unconditional ceasefire, for humanitarian pauses to facilitate the delivery of aid, and for accountability for violations of international law by the two warring factions, the Sudanese Armed Forces and the Rapid Support Forces. The UAE has repeatedly called for a political process to transition to civilian rule, and it supported and engaged in regional and international mediation efforts to bring an end to the fighting. From Jeddah to Manama to US-led mediation efforts last year in Switzerland. Through the US-led mediation effort, for example, we succeeded in getting aid to Zamzam displacement camp. With our partners, we have pushed the warring parties, both the Sudanese Armed Forces and the Rapid Support Forces, to meet their obligations under international law, to protect civilians, and to facilitate unimpeded delivery of humanitarian assistance. Most recently, in February 2025, just weeks before the applicant filed this case, the UAE co-hosted with the African Union and others a high-level humanitarian conference for the people of Sudan, with the participation of the United Nations Secretary General. In stark contrast, the applicant has single-mindedly pursued a military victory at the expense of a peaceful resolution to this conflict. They rejected the UAE's offer to establish a field hospital in Port Sudan to alleviate the suffering. They rejected calls to return to talks in Jeddah. They walked away from discussions in Manama. They refused to attend the US-led mediation in Switzerland. So when the applicant suggested this morning that it had no choice but to file this case, that is just not true. The applicant rushes to this podium in The Hague, but for 2 years, it has left its seat at the negotiation table empty. Mr. President, against this context, the idea that the UAE is somehow the driver of this reprehensible conflict in Sudan could not be further from the truth. This case is the most recent iteration of the applicant's misuse of our international institutions as a stage from which to attack the UAE. At every occasion, including here today, the applicant has leveled allegations that are at best misleading and at worst pure fabrications. Allegations which the UAE has conclusively rebutted, including as documented in our letters addressed to the President of the Security Council. This reflects an irresponsible pattern of behavior. Rather than working for peace and ensuring that humanitarian assistance reaches people in need throughout Sudan, the applicant has consistently sought to distract attention from their own culpability by blaming others. The applicant would rather come to this court than take basic steps to support the Masalit people. They have refused to allow the United Nations to establish a permanent international humanitarian presence anywhere in Darfur. The applicant must cease its deliberate and indiscriminate attacks on civilians. This obstruction of humanitarian access and its other violations of international law must stop. Mr. President, members of the Court, following these opening remarks, Counsel for the United Arab Emirates will now address you in the following order. First, Professor Mathias Forteau will show that the Court manifestly does not have jurisdiction in this case. The sole basis of jurisdiction invoked by the applicant is Article 9 of the Genocide Convention. It is clear, including from the case law, that provision cannot confer jurisdiction upon the Court, given the United Arab Emirates reservation. Professor Forteau will be followed by Sir Michael Wood, who will respond to what the applicant has said by way of legal argument to claim that the Court has jurisdiction in this case. It is clear beyond doubt that there is no jurisdiction. We therefore call upon the Court to remove the case from the general list. Lastly, Ms. Alison MacDonald will show that even if the Court had jurisdiction, which undoubtedly is not the case, the applicant has not begun to establish that the other criteria for the indication of provisional measures have been met. In particular, the claims made by the applicant lack all plausibility. The applicant has not produced a shred of evidence to support its outrageous assertions. Our agent, Ambassador Amir Al-Hafeiti, will then make concluding remarks and read out our final submissions. I thank you, Mr. President. I now request that you invite Professor Forteau to the podium.
I thank the co-agent of the United Arab Emirates for her statement. I now invite Professor Mathias Forteau to address the Court. You have the floor, sir.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. Mr. President, honourable members of the Court, it's an honour for me to appear before you this afternoon on behalf of the United Arab Emirates. As your Court is increasingly busy, we have to use as little of your time as possible and focus on the main points. The main points are very clear in the current case. Given the principles that rule over your jurisdiction, there is obviously no grounds for jurisdiction in the current case. Therefore, the case must be struck from the general list at this very stage of the proceedings. According to well-established jurisprudence, the Court has jurisdiction in respect of states only to the extent that they have consented thereto. When a compromissory clause in a treaty provides for the Court's jurisdiction, that jurisdiction exists only in respect of the parties to the treaty who are bound by that clause. However, in the present case, it is manifest that the compromissory clause relied upon by the applicant manifestly does not bound the parties. Indeed, as it acceded to the Genocide Convention in November 2005, the United Arab Emirates expressed a reservation to the compromissory clause in Article 9 of the Convention. It follows that the article is not in force between the parties to the proceedings and therefore cannot establish the Court's jurisdiction. This manifest lack of jurisdiction also appears in the very wording of the application instituting proceedings. The applicant refers to Article 9 of the Convention, the Genocide Convention, as the only grounds for jurisdiction, but also indicates that the United Arab Emirates have expressed a reservation to said Article 9. Thus, the application implicitly, but necessarily, states that the Court has no jurisdiction. Now, Mr. President, I could leave it at that, because that settles the matter. But seeing as against any reasonable approach, the claimant stated this morning that it was entitled to refer the matter to the court, I have to explain why there is manifest lack of jurisdiction in the current case. I will then draw the consequences that you have to to come to and draw the conclusions in the current proceedings before I make a few final comments. As concerns jurisprudence, and regardless of what the applicant's counsel stated this morning, the facts are very clear and simple. They all point in a single direction. Manifest lack of jurisdiction on your part and a fortiori, your lack of prima facie jurisprudence. Mr. Wordsworth artificially split hairs this morning to get you to believe that the issue of jurisdiction would be very complex in the current case. The obvious purpose of his presentation was to bypass your well-established jurisprudence on the case. And I insist, because it relates to the objective issue of your jurisprudence, of your jurisdiction, sorry, this jurisprudence does not rely on the arguments that he put to you, contrary to what he said. Your jurisprudence is perfectly clear. The court lacks jurisdiction whenever there are reservations to Article 9 of the Genocide Convention. As I will say and show you in a few moments, that is what you found in 1999 in the legality of use of force cases, and again in the 2000s in the DRC against Rwanda case, and something that you, in fact, confirmed very recently in 2023 in the allegation of genocide cases. You simply need today to apply this well-established jurisprudence, a jurisprudence that is an expression of the balance reached decades ago in treaty law. But before I come to the effect of the UAE's reservation, let me first of all state and recall that Sudan claims as sole grounds for jurisprudence Article 9 of the Genocide Convention. Therefore, should the article not apply, the court would necessarily lack any jurisdiction. Only the consent of the respondent could establish jurisprudence under Article 38, paragraph 5 of the rules of the court, but as was clearly stated, included in the letter sent by the UAE to the court on the 11th of March, the UAE have not given consent and do not intend to do so. The sole grounds claimed for jurisdiction by Sudan in the application, Article 9 of the Genocide Convention, was the object of a reservation expressed by the respondent when it acceded to the convention. And the effect of the reservation is obvious. Under the well-established rules of treaty law, this reservation renders Article 9 inapplicable to the United Arab Emirates, and the article cannot serve as grounds for jurisdiction. And the text of the reservation and the underlying intent is perfectly clear. As you will find in the documents found in your bundle, there are a number of documents that settle the matter. First of all, the United Arab Emirates state that they are expressing a reservation, as is obvious when looking at the Arabic language word used in the original version, and as is also clear from the translations from the United Nations. This precision, this clarification, which refers specifically to treaty law, is key. The stated intent is clearly not to be bound by part of the convention. It is not an interpretive statement or a commentary or anything else. It is a reservation in the legal sense of the word. Secondly, the reservation is precisely worded. It refers to a specific provision of the convention, Article 9. You cannot therefore misunderstand the object of the reservation. It clearly and specifically refers to the court's jurisdiction under Article 9. Thirdly, the way in which the reservation is worded and structured is clear. It, first of all, states that the United Arab Emirates are expressing a reservation to Article 9 and then restate and recall the content of said article. This obviously means that the reservation excludes the application of the whole of Article 9, including what Article 9 says is included in itself when it refers to a number of things, introducing it with the word including. Fourthly, the reservation expressly recalls that Article 9 of the Convention allows for disputes relating to the Convention to be submitted at the request, to admit it to the court, at the request of any of the parties to the dispute. By recalling this reservation clearly indicates that its object is to exclude the unilateral referral of a dispute to the court without the consent of both parties. And this is important as concerns the claims of Sudan. Indeed, both in the application and the provisional measures request, the applicant invokes the possibility of submissions by one of the parties of a dispute to the court. Yet that is precisely what is being excluded by the reservation of the United Arab Emirates. As the wording indicates, the UAE have expressed a reservation on Article 9 relating to the referrals to the court of disputes at the request of any of the parties to the dispute. And because of this reservation, Sudan simply cannot refer a case to the court. Moreover, the application, the provisional measures request, and Sudan's letter dated 28th of March show that the applicant state had, up until this morning, perfectly understood the effect of the reservation, that is, the exclusion of the court's jurisdiction. Indeed, it is to go against that effect that in its writings, in its submissions, it challenged only, and until this morning, the validity of the reservation. And Sir Michael Wood will come back to this shortly. And in this respect, I must admit to not having fully understood Mr. Wordsworth's lengthy descriptions this morning of how reservations may be drafted. No one challenges the fact that other reservations are not worded in the same way as the Emirati reservation. But the opposite is also true. There are reservations drafted along the lines of the United Arab Emirates reservation, and whose meaning no one has ever challenged. And that is, for instance, the case of the reservation of Spain, which the court gave full effect to in 1999, and also the case for the reservations of the compromissory clause of the 1967 protocol to the Convention relating to the status of refugees, or to the Vienna Convention on the law of treaties, a compromissory clause. Sudan itself indeed used a similar wording in its reservations, for instance, as concerns Article 26 of the 1951 Convention on the status of refugees, and I doubt that its council would challenge the validity of this reservation. In any case, the only important thing is to see whether the reservation of the United Arab Emirates is drafted in such a way that any reader would immediately understand the object and effect of the reservation. And it is clearly the case. The reservation states what it states and states what the intent is, an intent that is in no way ambiguous. Mr. Wordsworth's supposedly interpretative speculation this morning have no basis in the way the reservation is drafted. And in line with your constant jurisprudence, which Mr. Wordsworth seems to have lost sight of, reservation to Article 9 must be given full effect. And as the Court has stated, it is for each state to decide upon the limits it places upon its acceptance of the jurisdiction of the Court, because this jurisdiction only exists within the limits within which it has been accepted. And your jurisprudence also states that conditions or reservations thus do not, by their terms, derogate from a wider acceptance already given. Rather, they operate to define the parameters of the state's acceptance of the compulsory jurisdiction of the court. The court also indicated that there is thus no reason to interpret them restrictively. Moreover, and still to be found in your jurisprudence, whenever a text limits your jurisdiction, those words must be given effect. In this case, it is obvious that the United Arab Emirates reservation aims at excluding your jurisdiction, under Article 9. If that weren't the case, one could well wonder what the reservation was for. Let me also state that this reservation was made in November 2005, and that is at a time when the court, only a few years previously, and I'll come back to that, had found itself to be manifestly lack jurisdiction relating to Article 9, and there was therefore no misunderstanding of this. The reservation was accordingly notified to the United Nations, and it is expressly shown to be a reservation on the official website of the Depository of the Convention. And it is on the basis of this depository notification of 6 December 2005, to be found under tab 3 of your bundle, that it was circulated to all the member states of the United Nations in application of Article 17 of the Convention. And the notification is perfectly clear. It clearly indicates that the United Arab Emirates have acceded to the Convention with a reservation on Article 9. Following the depository notification and its circulation to all member states of the United Nations by the Secretariat, Sudan raised no objection to the reservation, and more broadly, no other state objected to it either, as Mr. Wordsworth recognised this morning. In accordance with treaty law, the lack of objection means that it was agreed to by Sudan, and Article 9 therefore does not apply in the relations between Sudan and the United Arab Emirates, and cannot serve as a ground for the court's jurisdiction. What is established in treaty law is confirmed by your jurisprudence. According to a basic principle of your jurisprudence that Mr. Wordsworth avoided this morning, and I quote, "The jurisdiction of the court is based on the consent of states under the conditions expressed therein, and the consent allowing for the court to assume jurisdiction must be certain." As the court has regularly restated, including recently, I quote, "The court must satisfy itself that there is an unequivocal indication of the desire of the parties to a dispute to accept the jurisdiction of the court in a voluntary and indisputable manner." When there is a reservation to the compromissory clause, it is manifest, as you state in your jurisprudence, that there is no unequivocal indication to accept the jurisdiction of the court in a voluntary and indisputable manner.
As regards the specific case of the Convention on Genocide, your constant jurisprudence is clearly established on this point and leaves no room for doubts. And as regards Article 9 in the reservation, when we see that Article 9 is the object of the reservation, the court then lacks jurisdiction. In the advisory opinion of 1951 on reservations to the Convention on Genocide, your court pointed out that invocation of Article 9 of the Convention depended on the reservations or objections that might have been stated in that regard, and the court recognized the possibility of expressing reservations to the Convention in a context where it would have been duly informed that Article 9 had already been the object of reservations by several states. In 1999, in the case of legality of the use of force between Yugoslavia and Spain, and between Yugoslavia and the United States, the court expressly noted its lack of jurisdiction in presence of reservations to Article 9. In 2006, in the case of activité armée, armed activities, the court reached the same conclusion. First of all, it recalled its own jurisprudence consisting in giving effect to such reservations to Article 9 of the Convention before concluding that it lacked jurisdiction in light of that basis. I would also note in passing that the court refused to consider that the reservation may have been withdrawn by the state expressing the reservation by expressing strict criteria and by lifting a reservation on Article 9. So that means that this Article 9 remains in plein effet. In these three cases of 1999 to 2006, the court pointed out in support of its decision on a lack of jurisdiction that as far as matter of law of the treaties is concerned, the claimant had not objected to the reservation expressed by the defendant. The same situation arrives in this case, where, as I just pointed out, Sudan has never objected to the reservation by the Emirates, and therefore Article 9 is prevented from effect in the case between both parties. I would further note, more recently in 2023, that you gave plein effet to a reservation of Article 9 of the Convention in your own order on the declarations of intervention in the case called Allegations of Genocide. The court expressly concerned on that occasion its jurisprudence of 1999, and it furthermore reminded that the reservation on Article 9 excludes the legal effect of that article in relation to the state expressing this reservation, and that in such a case, Article 9 of the Convention is thus not binding upon this state. I would further note in passing that this reservation applies also in this case when the reservation on Article 9 works against the state. You have expressed that reservation on Article 9 prevents the state expressing the reservation to intervene in the case of interpretation of Article 9. This once again shows that you have a rigorous and constant application of your jurisprudence concerning the effects on reservations to Article 9. Very clearly, the court has never refused to give full effect to reservation on Article 9, and there is strictly no reason to act in any other way in the course at hand today. It is therefore manifestly clear that the court lacks jurisdiction in the present case. This brings me, Mr. President, to the consequences to be drawn at this stage of the case, as I have been pointing out. If at the case level of the provisional measures, the court may not need to establish that it does have jurisdiction on the merits, it might only address whether it has prima facie jurisdiction. There are, however, situations where not only may the court decide, but it must decide on the matter of its jurisdiction at this stage of the provisional measures. Very recently, the court reminded us that it may strike off its docket case during the provisional measures stage. In the manifest absence of jurisdiction, this is obviously the case as to the decision that you must now take. The court has underscored in 1999 in a very clear manner that in a consensual jurisdiction system, to maintain on the general list a case upon which it appears certain that the court will not be able to adjudicate on the merits would most assuredly not contribute to the sound administration of justice. More generally speaking, and as Judge Lack had pointed out many years ago, the trust that states place upon the court depends on the full respect for the consentment to jurisdiction. This wise thought has never been as true as it is today. The court can only act and maintain a case on its docket if both of the parties concerned admit to its jurisdiction. And as I have said very clearly, this is not the case today. The court is not a place for us to address policy or to address the media. Keeping a case on the court's general list would thus represent a means of weaponizing the use of provisional measures as a Trojan horse so as to request provisional measures without any grounds for jurisdiction. And this would be tantamount to circumventing the principle of consent to jurisdiction, which is a principle that you have reminded us many times as to its great importance. Striking the case off the general list of the court will therefore be in keeping with the court's jurisprudence. And I would point out that in 1995, in the second case on nuclear tests, the court examined its jurisdiction even before it looked at the request or application for provisional measures. The court considered that it first had to decide in limine as to its own jurisdiction, and having concluded that it did not have jurisdiction, it then struck the case off its general list without even holding a hearing on the provisional measures. More relevantly to this case, the court decided in 1999 on the case of Yugoslavia v. Spain and Yugoslavia v. the United States that I have already mentioned, that in light of a reservation put forward by each of the respondent case concerning Article 9 of the Convention on Genocide, and I quote, "This said reservation had the effect of excluding that article from the provisions of the Convention in force between the party." Thus, in consequence, Article 9 of the Genocide Convention cannot found the jurisdiction of the court. And it arises that this provision does not constitute a basis of jurisdiction in the present case, even prima facie. And as a consequence, the court cannot therefore indicate any provisional measure whatsoever, and the case must be struck from the court's general list. And the same applies in this case before us. I would like to point out that the lack of jurisdiction is all the more manifest in the case of reservations to Article 9, and it requires striking of the case from the general list when what we have here is a pure matter of jurisdiction, the examination of which is totally independent of the allegations or the claims by the claimant. Regardless of the nature of these claims, this is not the issue. And when the only compromissory clause mentioned by the claimant does not apply in the conventional relations with the respondent, which is surely the case here, the court clearly has no competence, and that's that. It is here a matter that must be decided as an issue in limine litis. Your practice here is very clear. When the only basis for jurisdiction is a compromissory clause to a treaty, the court always starts examining its jurisdiction by looking at two preliminary points, even before it seeks to identify the actual object of the claim or the object of the claims, or looking at the extent or scope of its jurisdiction. The court has always looked first at whether there is a convention in force between the parties and whether the parties have expressed reservations. And you conduct this initial preliminary verification as regards the compromissory clauses. Therefore, these are indispensable prerequisites to the addressing of any case, even on a prima facie basis. This is what the court did in the case of the first order for provisional measures in the case of South Africa vs. Israel. You started with a preliminary observation on jurisdiction by saying that the two countries are parties to the Genocide Convention and that neither the parties to the Genocide have entered a reservation to Article 9 or any other provision to the Convention. And it is only after having made this preliminary ascertainment that you addressed your issue of jurisdiction prima facie basis. This is something that you have done in many other cases, in the case of Gambia vs. Myanmar or in the case of Ukraine vs. Russia. This practice confirms the issue of whether Article 9 of the Convention is applicable in the question between the parties and whether this is something of a preliminary nature. When addressing this issue, clearly exposes the manifest absence of competence on the part of the court. This issue must be decided upon at the earliest possible moment, and contrary to what we heard this moment, you need no additional document nor additional information. You have before you all of the elements to decide at this stage of the proceedings. And it is exactly in this way that the court has proceeded in previous orders that it put out in 1999 in the case of legitimacy of the use of force that had been presented to the court by Yugoslavia. I would also remind you of other cases where a reservation paralyzed application of Article 9, and that was the issue of Spain vs. the United States, where the court struck from its general list without further examination. It struck the case without a further examination of the provisional measures. And in other cases, the court has declared as follows, and I quote, and that is that it is not contested that the claimant is a party to the Genocide Convention without reservation, and that Article 9 of the Convention therefore would seem to be a basis on which the court's jurisdiction could be founded, provided that the object of the claim is the interpretation, application, or implementation of or fulfillment of the Convention. This quote doesn't leave any room for doubts. There is not even a possibility of a doubt on jurisdiction, only if there is no reservation to Article 9. It is only when the states accept the Convention without reservation that Article 9 might constitute a potential base for jurisdiction. However, when we do have a reservation on Article 9, then there's not even any point in asking about jurisdiction, because the court clearly lacks jurisdiction in such a case, and the case should be struck off the court's docket. Mr. President, it is now time for me to end my presentation. I would like to remind you of the key points. The present issue is very simple on the question of jurisdiction. On the basis of jurisdiction has been mentioned, and there has been a reservation expressed against this jurisdiction. This reservation is perfectly clear as to its purpose and effect, and it excludes the application of Article 9 of the Genocide Convention. This reservation has been duly notified, and Sudan has never objected to this reservation. It is therefore at the moment when the court was seized of this issue that it is deemed to have accepted this reservation. Article 9 is not part of the provisions in force between the claimant and the respondent. Your jurisprudence is clearly established in this sense and has been further confirmed recently, stating that a reservation to Article 9 of the Convention on Genocide makes this provision inapplicable before the court. It arises that your court is manifestly lacking jurisdiction, and that lacking jurisdiction, the affair should be struck at this stage of the proceedings from the court's general list. And maintaining the affair on the court's general list would run counter to the good administration of justice and would seriously put to question the principle of consent to jurisdiction. Ladies and gentlemen, judges, I would like to thank you for your kind attention. I would now thank you, Mr. President, to call Sir Michael Wood to the podium.
We thank Professor Folto for his statement. I now call Sir Michael Wood to the podium. Sir.
Mr. President, members of the court, it's a privilege to appear before you, and it's a particular privilege to do so on behalf of the United Arab Emirates. As our co-agent and Professor Folto have explained, the absence of jurisdiction in the present case is manifest. The case should therefore be removed from the general list. As Professor Folto has just shown, our opponents have not begun to make a case for the jurisdiction of the court. As Professor Folto has also stressed, it is fundamental that this court's jurisdiction depends upon consent. We heard nothing this morning from our opponents about that principle. The sole basis invoked by the applicant is Article 9 of the Genocide Convention. The UAE has in place a reservation to Article 9. The UAE has not consented to the court's jurisdiction. That is the end of the matter. I propose, nevertheless, to look at 2 points concerning the applicant's claim that, despite the UAE's reservation to Article 9, the court has jurisdiction. We find that assertion with very little by way of argument in the application, in the request, and in the agent's letter to the registrar of the 28th of March. I shall first look at the claim that the reservation is somehow invalid. Second, I shall point to the applicant's acceptance of the UAE's reservation for the last 20 years, that is until 5 March 2025, when it commenced the present proceedings. Third, I shall turn to the DRC Rwanda case, where the arguments now raised again by the applicant, were carefully considered and firmly rejected. I shall then make some concluding remarks and emphasize why in our submission the case should be removed from the list without delay. I shall first consider the applicant's claim that the UAE's reservation is invalid. As Professor Forteau has explained, the applicant does not contest that the UAE made the reservation to Article 9 when it acceded to the Convention on 11 November 2005. And it does not claim, and it has never claimed over the next 20 years, to have objected to the reservation, or to have claimed that the reservation was invalid. Only now, for the first time in these proceedings, does the applicant seek to challenge the reservation. I note in passing that in doing so, the applicant appears to assume that if the reservation were invalid, Article 9 would be in force as between the UAE and Sudan. That, of course, is not necessarily the case. Given the UAE's clear intention not to accept Article 9, even if Sudan were right about the reservation's invalidity, quod non, as some would say before you, the Convention would simply not be in force for the UAE without the benefit of the reservation. I recall that in this connection, the guideline 4.5.3 of the International Law Commission's 2011 Guide to Practice on Reservations to Treaties proposed de lege ferenda, a middle solution to this dilemma, to soften that outcome. But that proposal was regrettably, in my view, not taken up by states. In any event, as I shall explain, it is plain, including from your well-established case law, your jurisprudence constante, that the UAE reservation is not invalid. Mr. President, members of the Court, as you will have seen, there was very little in the documents instituting proceedings and requesting provisional measures to sustain the applicant's position on jurisdiction. We heard a little more this morning, but what we did hear did not strengthen the applicant's case. To the contrary, old arguments were resurrected that have already been authoritatively rejected by this court, by the International Law Commission, and by states. The applicant's arguments this morning were not new. They were raised and overwhelmingly rejected by this court in the DRC Rwanda case. One thing is clear, the only title of jurisdiction that has been raised by the applicant is Article 9 of the Convention. In the application, immediately after quoting Article 9, the applicant stated boldly, and I quote, "Therefore, the court has exclusive jurisdiction on the merits of this proceeding." The request for provisional measures asserted that the UAE's reservation was incompatible with the object and purpose of the treaty. In a letter transmitted to the Registrar on 28 March 2025, which is at tab 5 of our judges' folders, the applicant cited Article 1 of the Convention and then asserted, and I quote, "ICJ is the only institution entrusted with fulfilling this purpose with authority to examine states' compliance with the Genocide Convention," end of quote. The letter continued along the same lines by saying, and again I quote, "Article 9 is the portal through which the practical implementation of all provisions of the Genocide Convention depends. Without ICJ jurisdiction, the Genocide Convention will have no enforcement mechanism. The Genocide Convention would have no purpose." That's what the applicants have said. We heard similar arguments from Mr. Wordsworth this morning, but this is a distortion of the Genocide Convention. It ignores its various provisions concerning implementation, including Articles 6, 7, and 8. It ignores the fact that over the years, no less than 30 states have reserved to Article 9, presumably without accepting that to do so would make the Convention ineffective, which clearly it does not. It ignores the fact that, as the Court has frequently had occasion to point out, the absence of the Court's jurisdiction does not relieve states of their international obligations, which they must perform in good faith. The letter of 28 March sought to bolster Sudan's argument by claiming that a statement that the UAE had apparently made during last year's occupied Palestinian territory advisory proceedings, affirming the UAE's recognition of the importance of the Court's advisory function, somehow, and here again I quote, constitutes a tacit acceptance of jurisdiction. Obviously, any such statement did no such thing, and I note that that point was not repeated this morning. Until this morning, we had seen no argument, just assertion, no reference to the extensive and consistent case law of the Court, to which Professor Forteau has taken you, which clearly shows that reservations to Article 9 are permissible and have repeatedly been given effect by the Court, including as recently as 2023. There was no reference to the work of the International Law Commission on reservations to treaties, no reference to the ILC's work on Jus Cogens. Counsel for the applicant, Mr. Wordsworth, sought to remedy this morning what had been lacking in the documents instituting proceedings, but I fear he did not succeed. The ILC's 2011 Guide to Practice on Reservations is clear. Guideline 3.1.5.7, to which Mr. Wordsworth did not, I think, take you, provides that a reservation to a treaty provision concerning dispute settlement or the monitoring of the implementation of the treaty is not, in itself, incompatible with the object and purpose of the treaty, unless certain strict conditions are met. The Commission based this conclusion on its recognition of the Court's jurisprudence on Article 9 reservations. It will further be noted that Guideline 3157 refers to two categories of provisions, those concerning dispute settlement, such as Article 9 of the Genocide Convention, and those concerning monitoring of the implementation of a treaty, such as are found in many human rights treaties. As regards the work of the ILC on Jus Cogens, it is worth noting that the Special Rapporteur on Jus Cogens, in his third report in 2018, referred to DRC Rwanda and concluded in no uncertain terms that, and I quote, The fact that a dispute involves a peremptory norm of general international law, jus cogens, is not sufficient to establish the jurisdiction of the court without the necessary consent to jurisdiction in accordance with international law. That conclusion was not challenged by the Commission or by the Sixth Committee when it debated the jus cogens topic. The argument that the jus cogens or erga omnes character of the substantive obligations under the Genocide Convention affects the possibility of reserving to the dispute settlement clause was already raised, considered and rejected, overwhelmingly rejected, by the court in DRC Rwanda. States and the court have acted on the basis of the validity of reservations to Article 9 at least since 1999, and indeed well before, and have not returned to the argument that was rejected in 2006. Sudan has not put forward any compelling reasons why the court should depart from its settled jurisprudence on the matter. I note in passing that in 2011, in its Guide to Practice on Reservations to Treaties, the ILC also said that in its 1999 orders, the court clearly recognized the validity of the reservations made to Article 9 of the Genocide Convention. Legal certainty requires that this established practice not be overthrown. I hardly need say that the importance of legal certainty is greater than ever today. Mr. President, members of the Court, the 2006 DRC Rwanda judgment dealt expressly and conclusively with the arguments that Sudan sought to make in its letter to the Registrar of 28 March, and again this morning. From the relevant parts of the 2006 judgment, one sees the remarkable similarity between the arguments raised in that case and again in this one. Allow me to read a short passage. And I quote, "The Court observes, as it has already had occasion to emphasize, that the erga omnes character of a norm and the rule of consent to jurisdiction are two different things, and that the mere fact that the rights and obligations erga omnes may be at issue in a dispute would not give the court jurisdiction to entertain that dispute." The court continued, "The same applies to the relationship between peremptory norms of general international law, jus cogens, and the establishment of the court's jurisdiction. The fact that a dispute relates to compliance with a norm having such a character, which is assuredly the case with regard to the prohibition of genocide, cannot of itself provide a basis for the jurisdiction of the court to entertain that dispute. Under the court statute, that jurisdiction is always based on the consent of the parties." Mr. Wordsworth sought to downplay this judgment by mentioning certain, he called them concerns, but he was not in any way convincing. They were all matters considered in the past, especially in light of the joint separate opinion in that case, to which I will come. The passage I've just quoted from the 2006 judgment was recently reaffirmed by this court in November 2024 in the Azerbaijan-Armenia case. After citing the passage in question, the court then said, and I quote, "That position has been consistently upheld by the court with regard to the question of jurisdiction." The position is thus crystal clear, as the ILC also found in its 2011 Guide to Practice. Mr. President, members of the Court, this morning Council invoked the joint separate opinion in the DRC Rwanda case. That joint separate opinion makes an important and thoughtful contribution to the question of jurisdiction under human rights treaties, but it does not assist the applicant as regards the Genocide Convention. I will make 4 points. Firstly, the joint separate opinion is just that. It is a separate opinion. The 5 judges did not dissent from the court's conclusion that Rwanda's reservation to Article 9 was valid. In fact, only 2 of the 17 judges did so, Judge Karoma and Judge Ad hoc Mavungu. Judge Karoma's dissenting opinion shows conclusively that the arguments put before you today were before the judges in 2006, and they were rejected by no less than 15 judges. Second point, in their joint separate opinion, the 5 judges acknowledged, and I quote, the court's repeated finding that a reservation to Article 9 of the Genocide Convention is not contrary to the object and purpose of that treaty, end of quote. Third, the main point that the 5 judges were making was that in their view, the distinction between substantive and procedural provisions might not be applicable in all cases, and suggested by way of example that the treaty bodies set up under certain United Nations conventions may well be central to the whole efficacy of those instruments. But they did not suggest that this was the case with Article 9 of the Genocide Convention. On that, as I've said, they voted with the overwhelming majority of the court in finding the absence of consent to jurisdiction, and thus the absence of jurisdiction. One of the 5 judges, Judge Al-Arabi, was explicit in his individual declaration. He, and I quote, accepted the findings and conclusions in the court's judgment as consistent with the statute and hence sound in law. In the same case, Judge Ad hoc Dugard put the position very cogently in his separate opinion. After welcoming, strongly I think, welcoming the court's express recognition of the concept of jus cogens, Judge Dugard said that the court, I quote, has, correctly in my judgment, rejected the DRC's submissions in holding that the fact that a dispute relates to compliance with peremptory norms such as genocide cannot of itself provide a basis for the court's jurisdiction, and that a reservation to the court's jurisdiction cannot be held to be invalid on the ground that it violates a norm of jus cogens. In so finding, the court has emphasized that its jurisdiction is based on consent, and that no peremptory norm requires states to consent to jurisdiction where the compliance with the peremptory norm is at issue before the court. Judge Ad hoc Dugard put it very simply. There are limits, he said, there are limits to be placed on the role of jus cogens. The request to overthrow the principle of consent as a basis for its jurisdiction goes beyond those limits. This morning, Mr. Wordsworth referred briefly to remarks made by Judge Awada at an informal meeting of legal advisors in New York in 2010. These remarks were made, as Judge Awada himself said, in a personal capacity. Judge Awada was, of course, one of the 5 judges who joined in the joint separate opinion. He, like each of the 5 judges, voted with the majority in 2006 to give full effect to Rwanda's reservation. Much has happened since Judge Awada made his remarks in